Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D Lerner. Glad you could make it. In this particular episode, I'd like to talk about essentially who can petition whom in immigration law. Now, there's all kinds of different petitions, and in this particular video, we're not talking about employment petitions. We're not talking about self petitions. We're basically talking about family petitions and who can petition whom. Because I get a lot of questions that come into my office saying, well, can my mother petition my aunt, or can my father petition my sister, or can my sister petition my, brother? I mean, it just goes all over the place. And I thought if I made a video that made it fairly clear that it would have a lot of your questions answered. Because just the other day, somebody came in and wanted to know if she happens to have an aunt who's 63 years old, who's a U.S. citizen, and wanted to know if she was too old to petition somebody, and if so, who exactly she could petition. So just with that fact alone, before I get into the preferences, let me just tell you that for a 63-year-old U.S. citizen, there's no age limit on if somebody's qualified to petition. It doesn't matter if they're 63 or 99. It doesn't matter. Of course, there are a couple issues you have to consider. One is if they pass away during the pendency of the petition, so does the petition itself. But then you can direct yourself to another one of my videos on humanitarian reinstatements, which basically brings the petition back to life. So that has to be taken into consideration. And then nextly, there is the affidavit of support issues. Someone cannot come into the U.S. Unless the petitioner makes sufficient money to show that that particular person will not become a public charge. Okay, meaning that they won't go off, the government for their needs. Although I have another video on what one can and cannot use as government assistance and not be considered a public charge. So in this particular regard, when I'm asked if a 63-year-old can petition, again, the answer is yes. I don't think really you have to worry about the petitioner passing away at that point, although it needs to be brought up just as an issue. But more importantly, a lot of times when someone is 63, by the time the visa becomes current, there will be a retirement of the petitioner, and the income does become a significant issue. Whether you can use the retirement, whether or not you can do all kinds of stuff that will allow the public charge issue to go away or not go away. So you also need to look and see if there is a joint affiant, meaning that if there's another USC or lawful permanent resident relative who will agree that they will be able to go forward and petition so that there's not a problem. So given those issues, let me give you the who exactly can be petitioned by her 63-year-old aunt. First of all, since she's a U.S. citizen, she can petition a single son or daughter who's over 21. Okay. She can also petition a married son or daughter who's over 21. She can also petition a brother or sister. Okay. And the brother or sister doesn't have to be over 21. And even though we're talking about 63 years old, if she got started late and happens to have children under 21, she can petition them as well. She can also petition a spouse if she's getting married at that later point in life. So you can see that there are a lot of different petitions that can be done in that particular case. So given that, let's go over the preference petitions so you understand who can petition whom. And I'll break it down for you. So first of all, and we're talking just about family petitions again. So first of all, You have to divide the petitions essentially into two major categories. One is immediate relative, or IR. Next is the preference petitions. Okay? And while the preference petitions have different categories and the immediate relative petitions have different categories, just keep in mind for now you have two major categories: immediate relative and preference. Okay? Now, if it's immediate relative, that means that there are no waiting lists for visas to become available. It means they are always available no matter how many. Now, that doesn't mean that you apply for it on day one and day three the person comes in as a lawful permanent resident, because we're not talking about actual processing times. But then again, it doesn't mean that after it's approved, you have to wait 15 years for the visa to become current either. And we're talking just about immediate relatives. So now let's talk about the breakdown of immediate relative petitions and who it applies to. And again, if you can get into an immediate relative petition, obviously that is preferable to a preference petition because there's no visa waiting and things can happen much, much quicker. So there are three immediate relative petition categories. One is a U.S. citizen petitions a spouse. Okay? Um, you can look at the policy reasons behind that. The reasons basically that Congress made the laws of immediate relative petitions is they believe that the familial relationship that is being discussed or being qualifying as an immediate relative petition are so important that it doesn't matter how many visas come in, it doesn't matter how many apply, those people need to be together. So it is spouse, okay, of a U.S. citizen. Next would be a parent of a U.S. citizen who's over 21. So, I get a lot of, emails and clients who say, well, I had a baby 6 months ago. Can I become a U.S. citizen now? And of course, the answer is no. First of all, they need to wait until the baby's 21 years old before they can get petitioned. But for those people who have waited or do have children who have become citizens and now are 21 years old, whether they're single or married, they can petition a mother and or father, both at the same time if they want, as U.S. citizens for the parents to become lawful permanent residents. And then finally, the other way around, U.S. citizens petitioning single children under 21. Okay, those are the three categories of immediate relative petitions that are so important that there's no visa waiting and the petition can go through immediately. Well, unfortunately, a lot of people don't fall into that category. They fall into what's called the preference petitions. And for all intents and purposes, the higher the number of the preference, the longer the wait. So let me break it down so you understand the preference petitions. Now, with the preference petitions, there are four preferences, okay, and referred to as, F1, F2, F3, and F4. F being family, and the number being the preference. Now, before we get to F2, let's just do F1, F3, and F4. Those deal with where the petitioner is a U.S. citizen, okay? So again, F1, F3, and F4 deal with where the petitioner is a U.S. citizen. Now, F1 is where a petitioner petitions a son or daughter who is single, okay, but over 21. That is the first preference. The third preference is exactly the same thing, except the son or daughter is married, okay? Again, the petitioner, U.S. citizen, of course, has to be over 21, petitions a son or daughter who's married. The fourth preference is a U.S. citizen petitions a sibling, okay? And because it's fourth preference, it takes the longest. Now, a nice little tidbit here. The longest waiting preference on planet Earth is fourth preference from the Philippines. It's now taking about 23 years to become current. So given that, you could apply tomorrow. It could be approved 2 days from now, but the person can't even think about applying to come into the U.S. for another 23 years. that's what waiting for a visa to become current does, but they're not all that long. Okay, now why did I leave the second preference off? Well, that's because that's the only preference of which involves a lawful permanent resident who's a petitioner, not a U.S. citizen. And the second preference is divided into two preferences called preference A, so it's F2A and F2B. Now, F2A would be a spouse and or children who are under 21 who are single. Okay, that's F2A. So a lawful permanent resident petitions a spouse, or a lawful permanent resident petitions a child under 21 who's single. That's a F2A preference. An F2B preference would be a lawful permanent resident petitioning a son or daughter over 21, okay, who's single. Now, here's a little tidbit, unfortunately, that a lot of people mistake that they fall into. You have an F2B preference petition, okay? Again, a lawful permanent resident petitioning a single son over 21, single son or daughter. And then what happens is the single son or daughter gets married, okay? And the petitioner's still a lawful permanent resident. Well, there are no preference petitions for a lawful permanent resident of a married son or daughter. So the second they get married, that petition is voided, and sometimes they've waited years and years, and sometimes they even go to the consulate for the interview ready to come into the U.S. and get their visa, only to find out that the moment they got married, it was automatically voided by operation of law. So be sure you consult an attorney on that so you don't make that mistake. Okay, so those are the preferences of all the petitions and the immediate relative petitions, all broken down into a nice little video. So if you liked it, click like, subscribe. I usually do videos once a week, unless it's a holiday, of course, and then we go from there. If you have subjects or questions on more kinds of videos you'd like, just send me. I'll be happy to see if I can incorporate it into my weekly video. Okay, more in the coming videos.